Mr. Tucker, you still have the floor.
Thank you, Your Honors. Your Honor, before I move to another point, I would like to deal one matter which is of critical importance to Mr. Ongwen, and this relates to the inferences that the prosecutor invited the chamber to draw on several good acts that Mr. Ongwen did towards men, women, and civilians during the charge period and also outside the charge period. And that to make negative inferences, or that draw negative influences, permit me even to criminalize that conduct to show that Mr. Ongwen had the capacity to defy Connie if he could carry out those orders. One, it is tried law, a matter of inferences, that the inference that the value to draw must be the only reasonable inference. And in this context, within the charge period, the fact that Mr. Ongwen conducted this on his own when he saw civilians, protected civilians, women, children, were under the threat, or were systematically being bombarded by the UPDF. He protected them. And also the fact that he refused when Connie gave him orders many years after, during the peace process, he gave him an order to kill the actually cultural leaders, kill members of the international community, and other significant personalities, including David Masanga and Honorable Ayena. Connie gave a order to kill, and when defied, cannot be criminalized, or you cannot draw negative influences from that, for the following reasons. First, those acts were consistent with international human values that the Rome Statute architecture protects. Secondly, they can be inferred to show that Mr. Ongwen did not have the requisite means rea to resist the orders of Joseph Kony alongside other brigades when Kony himself was monitoring by radio, by intelligence officers which the prosecutor admits, concedes in their brief, were watching. He could not. But when he had the requisite means rea, he protected people, he protected victims, women, children. He took care of them. And therefore, Your Honor should decline to draw the negative influences. With regard to the actually cultural, the royal fathers as it be, you remember the impassioned appeal when made, devastating appeal, before the cultural leaders when Iraq reported. They talked about education have been ruined. I'm devastated. Now, that is not the image of the Ongwen, the callous Ongwen that the person wants to project. When he came in touch with the cultural leaders, he was making an impassioned plea based on his own personal circumstance in the bush that the cultural leaders should ensure that the peace process prevails so that he and others can go back and rebuild their lives. This is the only reasonable inference you can draw from this. And to say that Kony, who had promised and told Ongwen that he wanted to ignite a third world war by killing members of the international community, killing Honorable Ayena, killing David Masanga, and the royal cultural leaders of the actual land, to exterminate, and Ongwen said no. As Honorable Ayena rightly said, Ongwen was prepared to die than to destroy the most valuable architect of unity, of peace, and the cultural identity of the actually cultural leaders and religious leaders. He was prepared to die. But did Kony excuse him for that? The evidence shows that Kony did not, because he took his time. P16 told the court how Kony demoted Ongwen to private, gave him 200 strokes of the cane, and condemned him to death, and was waiting execution, but was rescued by some of the executioners. who knew Ongwen to be a good man, and Ongwen fled. We cannot reveal their name because these individuals are still in the bush today. But Kony executed so many people for being responsible for Ongwen escaping and coming to surrender to face justice. But wait for a while about inferences. The evidence shows by the defense victims that P78, the prosecutor's intermediary, who doubled as liaison, who also doubled was a senior counterintelligence commander in the UPDF. During the peace talks, he took back the victims back to Kony alongside with children. Some came back pregnant. They were lucky. Some of those children have never come back. And indeed, one of the women came back and was raped by UPDF soldiers and died as a result. You had the evidence on record. So, Your Honors, if the prosecutor's own intermediary could not resist the demands of Kony to take back victims who had been rescued to Kony, and some are still there today, and the prosecutor could not even investigate, could not even dare to investigate their own intermediary, how do you expect Dominic Ongwen in captivity to dare Joseph Kony without consequences? I beg to ask. The next point I will move to, Your Honor, is about the question of discriminatory intent. Your Honors had evidence from this Rule 68 by P28. P28 evidence is important for three reasons. He says, one, after Iron Fist, the main motivation of Kony was survival. He abandoned the political objective of taking over power, was survival. There was systematic bombardment over Sudan and the territory, and he ordered Vincent Oti to take back some of the commanders, some of the fighters, in order to distract the attention of the UPDF on him. Now, two, he ordered that food should be looted, pillaging from Uganda and brought to him in Sudan. You have evidence of prosecution witnesses, led by the prosecution themselves, how this food looted. They were not carried to Mr. Ongwen, and there's no evidence, scanty evidence, that food looted in any of these camps were ever carried to Ongwen. At least one of the witnesses said he carried food he looted from Lukudi to Tulu, but there is no clear evidence. But you saw evidence from P12, Rule 68, and other prosecution witnesses that they carried food to Kony for his own sustenance, and also sustenance by the women and children who were with the LRA soldiers. So the question of discrimination intent, P38, who was present when Kony set the rules, he was one of the founders, was very clear that the objective change completely was survival. So you must know that Iron Fist put a stop to the political objective of taking over the government. About the women, P28 says, and this contradicts the prosecutor who says they concede that Kony was central to the adoption and distribution of women, at least until after Iron Fist. Rule 68, P15, talks about the adoption of those girls, distribution of those girls. Senior Brigade was not involved because they have been banned. Remember paragraph 104 of the amended arrest warrant were called Oti, Kapari, and Tabule were involved. And P115, P115, Your Honors, gives a very moving account of what happened. He said, I don't know Dominic Ongwen. I've never seen Dominic Ongwen. I don't have a Dominic Ongwen. Because the evidence of adoption and distribution of women in this case comes from TESO, comes from the event, the adoption which P15 talks about. There cannot be adoption in the abstract. There must bring evidence it is not just speculation. He took part in adoption. Where is the evidence? Within this time frame, Ongwen was in the sick bay. And was in the sick bay? Yes. P205 confirmed. He carried him. He was nearly dead. Did he have a radio? Again, P205 says no. P440, whom you know, Your Honors, and I will not describe his attribute because everyone will know, but he was one of the closest commanders to Joseph Kony. He was the heartbeat of the system. He was the highest commander who came here to testify. He said there were no radios at the level of the battalion. No radio at the level of the battalion. And you have the prosecutor witness evidence saying that Kony was telling Oti that he should give a radio to Dominic when he was promoted. If he had a radio, why would Kony be saying that he should be given a radio? In any case, when I get to the intercept evidence, I will indicate, I will prove that even Lapacho, the evidence showed that Lapacho were allegedly reporting acts of attacks committed by Dominic. So if we had a radio, why would the prosecutor say Lapacho was reporting this act? So the fact that he had a radio was able to command, Your Honor, is not proven by the evidence. It's mere speculation. Now, Your Honor, let me venture to, of course, the question of child soldiers before I go to the intercept, which is longer part. Your Honors, P28 again says the adoption of children became problematic during after Iron Fist because of the movements. They were not in one location, and that there were systematic bombardments, and therefore it was difficult for them to adopt and train. Adoption may have taken place in Teso, where there was no bombardment, and where Kony concentrated his effort, as you will see. But Dominic Ongwen did not go to Teso because P16 said he visited him in the sick bay. And there is overwhelming evidence that he was in the sick bay. He didn't go to Teso. And it's in Teso that witness after witness, prosecutor came to say they were mad adopted and gave the location. And some of the victims saw them. It is not enough to say that you saw people whom you characterize as being young people as escort, because you have first to establish when were they adopted and by whom. Was it within the time frames? That evidence was never given. And I can only concur with Mr. Fusa when at the beginning of the Article 56 that he rebuked the prosecutor about the tendency of leading evidence out of the time frames. And one of the inadequacies, deficiencies that this trial suffers, the prosecution case suffers, is the inability to establish time frames, to establish at least the ages which they concede in paragraph 75, that many of the witnesses could not even establish their ages and are now bound by speculative indicators. But they had the ability to call expert evidence. They had the ability to talk to the parents of these children because the Convention on the Rights of the Child says evidence of age given by parents, even though no record can be accepted. Yes, witnesses can give evidence of age, but they must give a foundation, a proper foundation, and the basis on which the evidence can be accepted as being credible. It is not just witnesses speculating on the ages of other victims under traumatic circumstances. That is not enough. It is not what Lubanga, the jurisprudence side of my friend was saying. Yes, you can accept independent evidence of witnesses, but it must be credible. You must be able to see the witness and assess the credibility of that witness and the competence to give evidence of age. This has not been done. The prosecutor is on a expedition here. The cobweb pleading of this case, and I call it the cobweb strategy of pleading everything, adopting everything, Your Honors, has helped to morally notice in this case, complicated the case. But it's a straightforward case, the late counsel said. The case is that they want you to hold Ongwen responsible for the conduct of Joseph Kony, alleged for executing the order of Joseph Kony. But what is lacking is this. With each charge attack having admitted that Joseph Kony ordered, the inquiries have started from Joseph Kony to say, when you order this attack, what safeguard did he put in place to show that they are executed? The evidence in the arrest warrant pleadings and paragraph 56 of the confirmation of charge decision shows that Kony had an elaborate communication network. It belonged to him. He had intelligence officers whom the prosecutor has considered were there. He mobilized all the units, and as the communication regime shows, he activated the entire system. They were on the radio during the order. And Your Honor should not forget, with regard to the case of Udek, you remember with P38, the chain of custody witness came. There was that entry in one of the reports where one of the investigators said, and I can produce a reference when I get there, it is low, but we can get the message from Joseph Kony. Joseph Kony was giving orders and receiving orders from meaning about the attack on Udek. And I asked, prosecutor, where is this audio? You let evidence Joseph Kony give the order, yes. Your witnesses are giving the evidence, yes. But the court would like to know, what did Joseph Kony say, and from whom was he receiving? Because it's contentious, highly contentious, who was reporting and who was executing the orders. That entry is very important for you to make determination with Udek and others. But apart from that, with regard to the intercept, as I get there, Your Honors, the prosecutor has escaped, completely abandoned his own evidence. P403 was the prosecutor's own internal expert who evaluated all the intercepts plus the reports for the court and testified and submitted into the record. Why would the prosecutor come and make demonstrations here, cherry pick notes here and there, and ask you to rely on them, notes that were tendered through the bar table, to convict on them, whereas the same notes have been discounted at 2 levels. 403 says that there were at least 5 or more interception sites in Sudan, in Lira, in Soroti, in Kampala, and different units, including the CID, that intercepted. And all these were sent to the Chieftaincy of Military Intelligence in Kampala for purposes of intelligence for war operations. And of course, the UPDF independent is also dependent on the direction of findings. What is material? What you should want to see is the end product. Where are the intelligence reports? We cross-examined 403 with the intelligence report with regard to Udek. That's the only intelligence report you have. There is no corresponding intelligence report for Lukudi, from Abok, from Pazule, and the inference is that the prosecutors were holding them or did not care to look for them. But with regard to Udek, the intelligence report at the highest level of the UPDF, where the UPDF military command used for war operations, clearly says Oshanga Bongo, who reported that he attacked Udek on the line in that communication, Governor Ongwen was on the line. Joseph Kony on the line, or all other commanders, when Ocean Labongo took credit for this. Yes. Furthermore, Your Honors, if that's not all, Your Honors, ask yourself whether this report, bit and piece of report, were all personal impressions of the witnesses or were contemporaneous reports. The witnesses themselves report difficulties. P59 says most of my staff did not understand actually. Or he himself did not understand actually. He told you about the conditions of work in his office with one of his colleagues. And he said that he personally made notes. He made his own notes in order to help the commanders in the form of analysis. P03, Your Honors, you saw him here. His side-step with regard to Odek clearly contained the name Ocean Labongo. And now you saw those notes later on over the Labongo put Ongwen by a different ink. We do not know at what time he made those impressions. Now, irrespective of what he said and what voice attribution he did here, what is important to this court is that the intelligence report that came out by his superiors and which are corroborated by the direction finding is that Ongwen was not there. Ocean Labongo, indeed, is the one who took credit for the attack of Odek. And furthermore, 403 has analyzed an entry where the question of the diamond, because the prosecutor alleges that when allegedly was overzealous and committed the crime because wanted promotion, whatever Kony. But again, they said the intercept shows that it was Labongo who reported to Kony that I found the diamond. And Kony said the person will be promoted, not Ongwen. And even the idea of allegedly committing crime because wanted promotion and that indeed was promoted is fallacious because 440, whom they brought here, and asked to listen to one of the intercepts, established the difficulties he had in listening to the intercepts. He said throughout the period he never saw Ongwen, he never met Ongwen. But when he listened to the intercept, he heard Kony telling OT that the spirit have asked him to promote certain officers. And that the spirit, the spirit promoted Joseph Kony first, promoted Ocean Labongo, promoted OT, promoted Dr. Ongwen, and P014, Lapacho, among others. So in the IRAD, it is the spirit that promotes. They conflict promotion with appointments to posts of responsibility or command position. Yes, Kony appointed Ongwen to command position, the way Lee has said. He never said, I'm sorry, please. Oh my goodness, stop. Now, about the appointment or not, there is evidence here that ARA lost so many commanders, Livingstone, Tabule, you can name it, many commanders. And that is what saved Ongwen from execution, because they were short of commanders. And Kony appointed him a commander, gave him that command position, but appointed a member of his close protection unit, Ocean Labongo, to be the second commander. 440, P440 says he knew him, they were in the same location, he was a close protection unit commander. And that's why you saw systematically he had a radio, he reported, and in any case, Your Honors, the evidence shows, and 403 has analyzed, that when P16 said that Ongwen was offered on the radio, he analyzed to find it was not true. He found that Ongwen was the least of the commanders on the line. He was never actually on the line. At one moment, Connie asked, and he said, yes, I'm here, suggesting that he had Connie's orders, but was not on the line. And because he was not often on the line, it wasn't possible to say that he was often on the line for people who were trained. Only in 2002, they started training a crash course for interception. By 2001, agency happened. By 2002, in November, Ongwen was wounded, and he was out without a radio for them to purport that they can identify the voice of Ongwen. And P03 says it, that it is difficult for him. And 403 in his analysis also say it was possible that commanders, the intercept signalers, could be sent to go on assignment with other commanders. And when they're on assignment with other commanders, because the UPDF attributed the voices of the signalers to their commanders, when these signalers were sent on operation with other commanders, and they were communicating, it was possible for the UPDF to continue to attribute these attacks to the commander to whom the signaler had been assigned. This is 403 saying this. You need to read the report of 403. You need 440, who had intimate knowledge about the distribution of radio, who had the radio. About the question of tonfas, there was no other expert about tonfas than him. Yet he says in 2004, when he was interviewed, the prosecutor did not play, contrary to what he said, any of the original intercepts to him. Neither was him asked to break the tonfas. Now, Your Honors, without breaking the tonfas, which he said, carried the orders of Joseph Kony, the evidence of the interview is insufficient, totally insufficient for Your Honors to be called to rely on in any respect to make a finding of guilt. In any case, irrespective of what the prosecutor said, that we rely on it. Of course, we're entitled to rely on it to establish reasonable doubt, to say there's reasonable doubt, because we don't have the burden of proof, the same standard as the prosecutor. So, as a matter of law, as a matter of fact, judging from 403, who analyze all the evidence, these other attempts in the courtroom to make scales and all what computer-generated scale evidence, which was never on the record, should be dismissed because 403, their own witness, their own internal expert, has submitted information before Your Honors. And each of that information, looking at the same material, as compared to Ongwen, even with Lukudi, there are three sources. Ongwen said, my sprinter force went out, and I'm waiting for them to come to find out what happened. And another intelligence source said, 10 Ebong is not on the line. I think that's a CID. But all of them equivocate. Ongwen was expressing doubt. It was not equivocal. Ongwen was expressing doubt. My sprinter force went out. They are not back, so I don't know what went on. There are two ways of looking at Your Honors. One of it is that they went to Gwendia, according to Ongwen, as P18 said. Another one is that they were a sprinter group. And the cause of contact, they lose touch and they move about. And probably he wanted to know, as every reasonable commander, whether they were involved or not. And when they came out, I remember one of the wives, 56 wives, said one was very angry with Chaka. One of the wives was very, very angry. I think it was about the second wife, I don't know, with him. He asked each of them, I'm hearing over FM, people died. Did people die? What happened? Each of them lied to Ongwen. Your Honors, by their own lies, by their representation, Your Honors, you should assess their evidence with caution. Secondly, there is no mainstay element. There's not even any active radios with regard to Ongwen's participation. Your Honors, what's the time?
It's about time.
Okay. No, Your Honor, one thing, Your Honors, I was forgetting. The confirmation decision talks about the question of the ARA being like conventional force, they have attributed conventional force. Your Honors, two important witnesses, UPDF senior commanders who came to testify, contradict Colonel Balek Kudembe and Colonel, 1 minute, let me, can you go here? Can you go here? They said that no, they did not consider them as having been a conventional force. Connie had no right to himself call himself general or when to call himself brigadier. They don't, under the methods of warfare were not those, and the way they led wasn't. Now, neither the prosecutor nor any of us was there in the field. Probably the only person who has intimate knowledge in this courtroom is Honorable Yena. But, Your Honors, when you have two critical, significant UPDF officers who were involved in the war operations, one was with intelligence at the Chieftaincy of Military Intelligence, who doubled as a lawyer, and one was the brigade operational commander who was facing Ongwen in Gulu. And he said these people did not have this attribute. On what basis is the prosecutor contradicting his own evidence of these individuals who are not just fact witnesses but could be military experts in their own right on command structure and military operations? On what authority would the prosecutor contradict the evidence of their own witnesses who will say that what matters, the most credible document that you will rely on were the intelligence reports, not pieces and pieces which have been rejected in the analysis which their own expert rejected? Or what credibility, Your Honor, I will beg to ask. And the last point I have to beg, Your Honor, before I hand over to my colleague, is on the question of pillaging. The prosecution argues in paragraph 249 of the closing brief that the defense did not provide formal notification of intention to rely on necessity as a ground for excluding criminal responsibility for pillaging under Article 31. Yeah. Your Honor,
Mr.
Taku, misunderstands the
Mr. Taku, I don't like to interrupt you, but I'm reminded to ask you to speak. I'm reminded to ask you to speak a little bit slower, so that the interpreters
I can't hear very well. I'm sorry.
Can follow. Yeah.
I'm finishing. I'm complete. Your Honor, the prosecution misunderstands the law. Element 2 for the war crime of pillaging under Article 8, sub 2, E and 5 of the statute requires the prosecution to demonstrate that the perpetrator intended to deprive the owner of the property and to appropriate it for private or personal use. The corresponding footnote 62 of this element clearly stipulates that appropriations justified by military necessity cannot constitute the crime of pillaging. The defense argues that the prosecution failed to prove beyond a reasonable doubt that the alleged appropriations were not justified by military necessity and did not prove the necessary elements for pillaging. We earlier, Your Honors, pointed to prosecution evidence on how Connie ordered. He made the order, the looted food was taken back to Joseph Connie in the context of the attacks we did themselves said were war crimes. There's another issue, Your Honors, that I want to address, which is paragraph 54 of the paragraph 54 of the charges, the document confirming the charges, which says that the finding of the protrial chamber with regard to the status and the command structure of the ARA could be used as contextual elements. We beg to differ, Your Honors. First, that finding does not constitute notice. We've said that there is a paucity of a plethora of pleading violations, complete lack of notice, and pleading of contextual element with regard to each of the charged crimes. You cannot use the cobweb pleading tactics, and also in the course of the trial, where the prosecutor acts apply to the court to lead evidence out of charge attacks to prove contextual elements. That could only, we objected, it could only have been valid if they were indeed pleaded. But this is not the case. And paragraph 54 and 56 do not meet a requirement of a state policy, the command structure, the statute on when. How do they meet that requirement? Either even of notice of a state policy or statewide policy. How do they meet the requirement of widespread and systematic attacks? They fail to meet the pleading requirements, Your Honors, for contextual elements in this particular case. 1 minute, Your Honors, let me leave.
Microphone, please.
I did not intend to take the court through the analysis of the intercept. It will take a very, very long time. But I hope that the court will read. And I just want to dismiss the unsubstantiated, unfounded allegations made by the common legal representative that in the paragraph 90 and 94 of their submission that there is no dispute among the parties at the relevance and probative value of the written transcripts and related items used during the testimonies of the witnesses, 6 of them are dual statute witnesses represented by the common legal representative. This was a misrepresentation that I expected my colleague to withdraw with apologies. Because, Your Honors, at the time of making this statement, she was aware that it was highly contested, either in the pleadings, either in the defect series, either at every turn, and also in the cross-examination. The question of ages were an issue. The question of the venue or geographic parameters. And of course, the prosecutor has not even dared. And to represent that among the parties, I don't know which parties, at least between the prosecution and the defense, we know that there's sufficient dispute about that. And Your Honor had opportunity in the conduct of this trial to observe matters related to Article 56 wives. We pleaded consistently, and we'll say it again, about their status. Now, what do you say if you put restrictions on the ground that there's the interference? Then the single judge now himself calls a status conference to say there's a problem with the witnesses. They don't want to come, someone to testify for Ongwen. And you say, oh, a witness is a witness. Well, yeah, I heard similar statements under a different context by Your Honor. And the context you made it was correct. It was not the context in which the witnesses themselves have expressed reservations. It expressed reservations, proper fair trial, and guarantee of fairness warrant you to hear them. Why do you want to come? You see, it's not what the parties say represent that matters. Why? Was there interference with you? Is it a result of interference? At that point in time, the reasons and the rationale for the Article 56 was clearly challenged. And that's why you had Assistant to Counsel, Mr. Tom Obof, based on the representation made by the judge, to say, I want to lead two of the witnesses. That is the context in which they understood it. And he now said no, and they fell back. And you make a general blanket assessment of vulnerability. International Criminal Tribunal for the past 20 years, more than 20 years, and before your honors, in another trial, this is the second trial before your honors, you have assessed vulnerability on a case-by-case basis. And if there's an interference, it's a serious allegation because it's Article 70. Your honors will either ask an investigation or at least you ask the witnesses about. It is about the witnesses, about what they required, their state of mind. And you've seen the state of mind roll out in these proceedings about wanting to meet and visit Mr. Ongwen. Now, we'll put in these emails between the prosecutor and the defense into evidence because you needed to know the state of mind. And two witnesses who were alleged to be at the base, at the origin of the alleged interference, came to testify. The one who had the NGO and one of the main person who did it. See clearly. I wish if I have the time to read out, and I think I will find it, and it's good I read out for impression for you to know what he clearly said, Your Honor. 1 minute, Your Honors. Your Honors, P28, Your Honors. And he says, while speaking in tongues, Connie said that the Spirit ordered him that children be taken to grow in the bush, because many of the older people were going to die of HIV, and the Spirit did not want the children to be infected. Because education which had been brought had spoiled children before they are even matured. They want to go out with men now, or men also, the same thing, want to go out with women before they were matured. Dominic Ongwen will submit was a victim of this policy at the opportunity when they implemented the policy, and not a perpetrator of this policy. And you have to look at the allegation against him within this context. What did he know? At the time of his adoption, he did not have any idea about sexuality, especially within the cultural aspect of that actually. And this is, we in Africa, that actually included, who have concerns about the question of morality among our children. This is a perverted version. Connie had the same concern, but his remedy was wrong, was to take them to the bush to grow. And that's why he imposed stiff laws, very stiff laws, and a very regular regime for children going to the bush for what he called rape, execution, and all whatnot. This is, the person was with him, present at the inception. This is what he says. P28 goes further to say, both men and women will go quietly when they distribute to them. Even if they didn't want it, because at least this way, they will go quiet, they will not complain, they will accept both men and women, they have no choice, because they want to be alive. This was the regime, these are the rules. And when interpreting the rules, Your Honors, they should interpret the rules completely, not in the abstract. Connie made the rules, but what is the full content of the rule? P28 gives you a full account of the motivation and how they were implemented. And now, about the implementation of Connie's order, Your Honors. The amended arrest warrant pleads the use of the radio. It also pleads the complete command structure of the ARA, at least until when the severance of the case, when our lead counsel said they now dump everything on Wen as a scapegoat. A scapegoat so the victims of Northern Uganda can go. You have no remedy, you have no hope. Too bad for people who have raised expectations to victims that Ongwen, who got Ongwen, there's no need to look for Connie. But again, P38, whom Connie gave a wife and he refused, and Connie summoned everybody, and he knew they was going to die, he accepted. Whom, after adoption of the girls were brought to Connie's location. He had some, released some. Of course, Ongwen was not given any, but P38 was given one, and he says that the moment you refuse a wife, Connie will call you saying that you want to escape. And about the disciplinary regime of Connie, make no mistake, he killed Oti Labongo. He killed Vincent Oti. He would have killed P205 himself. He told you Ongwen saved his life. Imagine if every commander, because Ongwen, they were the ones sent go. And when Ongwen, at this time, Ongwen had become more senior outside the time frame, how many witnesses came here and said, before Ongwen will be dead? You heard a witness that said, like when he said, this will attack our watch Is it a witch? A witch? Eh? A watch. When, at that time, told the people, don't. Because Ongwen was not involved, was the execution, the entire command structure had not been activated. These orders were given to a different commander or a different unit. And Ongwen said, no, if you have a way. Then the commander, they came back. But when Connie has given his orders and he's watching, with the IOs, intelligence officer whom the prosecutor concedes, were there watching. And Connie is there. And 440, P440 says, when Connie has given an order, an operational order, that nobody is going to be at peace until that order is executed. If not, there will be dire consequences. And you had P205 saying that when Ongwen had this contact with Salim Saleh, Connie gave an order to Okongo Alero to constitute a task force and go and kill Ongwen. P05 was a member of the task force to go and kill Ongwen. He was pursuing witness. That Okongo Alero was to go and kill Ongwen. But later on, he changed his mind to say because the phone was still there, let him come with the phone and brought him and put him in control order. You had a lady commander in control order who participated in the attack in Pajole, giving complete exculpatory evidence about Ongwen. She testified about women issues and the procedure in place to resolve complaints. Yet evidence, prosecution evidence, how Connie executed his chief intelligence officer Ongwen for raping his own wife. You had evidence how Connie meted punishment at every turn. You had evidence of one of the commanders who fled. And you asked him, Your Honor, asked him, the president asked him, you told him when he wanted to escape, he said yes. Were you not afraid that Ongwen will go and betray you to Connie? He said, absolutely not, not Ongwen that I know. But that by the time I was escaping, everybody knew that Ongwen was a dead man. Ongwen would be killed at any time. Ongwen himself was aware that he was going to die. Remember that witness? When Mr. Obof wanted to ask me a question about what happened in Central Africa, he said, no, I didn't come here for that. But he was very categoric that Ongwen knew, and everybody knew, every commander, that Ongwen was a candidate to die. How do you know that when Connie started talking to you, and the way he was talking about Ongwen, everybody knew that Ongwen was in the radar to die. This is prosecution evidence, Your Honors. Men, women. Women came here, you asked them. You met Ongwen, say, how was he? Say, Ongwen was a good man. Ongwen was a commander, but he would talk with everybody. He would empathize with the condition of everyone, showing that where is the mainstay? Someone who had a mainstay. Someone who has a mainstay to commit these crimes will not have witnesses saying this. You saw after witnesses, they wanted to greet Ongwen. They said, when we heard Ongwen had surrendered, 20 of us rushed to Gulu to go and welcome him. But he was here. You had witness overwhelming majority. And Ongwen himself told me that Connie predicted that one of us here will go to one institution in the world to talk about the AIA to the world. Now his prediction is like that Ongwen is here. But the difference is that the image of Connie looms large in these proceedings. Looms large even in this courtroom. If you look at the case the prosecutor submitted to Your Honors, 75% is about Joseph Kony. Less than 10%. 10% about other people, undisclosed commanders, considering the defects, the defective notice and defect pleadings. But only about 15% is about Ongwen. They only bring in Ongwen to say he executed the order of Kony. Now, do you have complete evidence? in order to, by the prosecution, for you to ascertain that this coin you are talking about, the focus was just on Ongwen. You have P3 saying when the prosecutor came to my office for the intercept, I had a lot of other information involving other commanders and their attacks. The investigator said, we only want material about Ongwen. How do you do that in a case when you're alleging multiple form of criminal liability, indirect perpetration, common plan, common purpose, liabilities? How does the focus on Ongwen prove the elements, even contextual elements, and the element of this crime? Ongwen alone in this court is meaningless. Makes this case a complete waste of time. This is not how to lay a case. And Honorable Ayana said one thing about the investigation. Take note, P78, who procured more than 40 witnesses, many of them who were former returnees, whom again he conscripted back into UPDF to continue their victimizations. And I want the victims to know that the victimization of your witnesses was not just because we were ARA, but because some of them who were victims were brought as victims back into UPDF. And who did this? P78. The prosecutor's note showed that he was involved in a scandal involving money from witnesses. The prosecutor's note showed he sat in during investigations. But take note, his own report, which we have, showed that Rascal Kuya, which contrary to the prosecutor when remained the only senior commander in Uganda, which is false, Rascal Kuya was number 3, only to Kony. He was the most senior commander. And the note showed that he was progressing to the safe passage when, and their own investigators' notes, P78 is saying that he got some of the returnees and some UPDF, and they set an ambush at Musiani, hoping to kill Ongwen and Rascal Kuya. Of course, Ongwen, a child of God, was not killed. He missed it. Rascal Kuya died. Here is a man, intermediarily, who was supposed to help the prosecutor to arrest Rascal Kuya and bring him to justice. Rascal Kuya had a warrant on his head. He was supposed to arrest and bring him. He chose to kill him. Your Honors, I can go on and on. My time is up. I can only make one impartial plea, Honors. You should not accept this victim to be used as a scapegoat, as a sacrificial lamb for the inability of the government of Uganda, the prosecutor, or the ICC to bring Joseph Kony to book, to account for his crimes, in which Ongwen will be a participating victim. Your Honors will urge you to acquit Ongwen for all the charges. Thanks, Your Honors, and I hand back to lead counsel.
Microphone, please.
All right, Your Honors, give me a few moments. I will do a half hour now, then at lunch break at 1, and then I still have 45 minutes, if my arithmetic is correct. Okay, let's see how I do. As I stand before the court today, I remember standing here almost 2 years ago when we opened the defense case, September 2018. And as I was preparing, many of my arguments were the same. So I will endeavor to make new arguments here, to discuss issues in the brief, and of course, to comment on issues which were triggered or sparked by the briefs of the participants and the prosecution and their remarks. As my colleagues have eloquently stated this morning, we are in this courtroom because Mr. Ongwen surrendered himself. That's the reason we're here. And in fact, each of us have said it differently, but this is a proxy prosecution. This is a prosecution, in my view, of the LRA. And the proxy part is that Mr. Ongwen is sitting there and not Mr. Coney. I will not belabor this point, but I think it's an important point conceptually, but also legally in terms of how this process operates and what are its objectives. Now, Mr. Ongwen, from the beginning, when he was asked to enter a plea in December 2016, told the court, "I am not the LRA." Each of us, as well as the prosecution, have referred to these remarks from December 6, 2016. My concern is that the process of going through a prosecution of a child soldier is objectively yet another victimization of Mr. Ongwen, our client. And I would extend it by analogy to all child soldiers who should have been protected by Uganda under international law. Uganda signed the Convention on the Rights of Children in 17 August 1990. They acceded to the optional protocol to the Convention 2002, which prohibited the recruitment of child soldiers under 18. At the end of the day, the person who will bear the consequences of this prosecution, of this proxy prosecution, and bear any penalties if they are determined by this court will be Mr. Ongwen. I represent Mr. Ongwen. I don't represent all the child soldiers in the world, obviously. But I think that this prosecution does send a message to child soldiers. And the issue is whether child soldiers should be held accountable for the crimes of their captors. And in this case, the captor being Joseph Kony. Now, 2 years ago, I remarked on Chief Prosecutor Bensouda's comments in her statement on the International Day Against the Use of Child Soldiers. Here we are, more or less a year and a half or so later. My arithmetic is not good. But a month ago, again, she made a statement on behalf of the prosecution. She said that crimes against children are abhorrent violations of fundamental rights. They shock our collective conscience. We must act to protect them. We concur with that sentiment. And again, I would offer the tactical suggestion that we made in September 2018, which is, given the tools at the disposal of the prosecution, there's certainly, if there were the will, there's certainly a way to have ended this prosecution, dismissed this prosecution, withdrawn the prosecution. I don't know the exact terminology, But one thing about the law in the Rome Statute is it provides, if you read it broadly, tactical options based on the law for all of us, for judges, for the prosecution, and certainly for the defense. We use them. And I'm saying the prosecution could have found a way to take a different stance in terms of child soldiers and not prosecute Mr. Ongwen. Now, the key issue on this point has to do with the age of culpability in the Rome Statute, 18. And the argument which has been discussed by my colleagues is that when someone turns 18, whether at the stroke of midnight or whenever, things don't change. You don't, I guess the word is metamorphosize. You don't change from one thing to another. And here we had testimony. I'm not giving evidence, but we had an expert who gave evidence before the court. He's been referred to as D133. D133 is a retired UPDF major who himself had been abducted in the 1980s by the UPDF predecessor organization, the Lord's Resistance Army, and who now has worked for years with ex-LRA. And his evidence is available, obviously, to your honors, and it's also public evidence. But the points that he made that are important to remember are that being a child soldier never ends. Its effects, especially the mental effects, the psychological effects, continue throughout one's life. The second point, child soldiers do not act on their own volition. And this was a point that was echoed in TO3's testimony as well. And lastly, in the LRA, a child soldier is in captivity. He or she has no control over his or her mind. There's no mental control. It is under the control of CONI. And we want to emphasize the importance of this. And in addition, I would point out to your honors, I know that we submitted, and I believe that the participants or the prosecution may have also submitted the report on the psychological effects of child soldiering by Dr. Elizabeth Scheuer, which had been used in the Lubanga trial as well to substantiate these points. Now, this is a case of legal firsts for prosecutions in this international court. This is the first prosecution here of a child soldier. It's the first prosecution of a mentally disabled person in this court who is asserting mental disease or defect as a complete defense. To my knowledge, it is the first prosecution of a defendant where duress also is being asserted as a complete defense against all charges. And lastly, this is the first prosecution of a single defendant or accused person for 70 charges and 7 modes of liability. These firsts present legal challenges to all of us, obviously. But they also present opportunities to the chamber. And I only ask on behalf of the defense that the chamber consider that today, as there are still in 20 countries approximately 250,000 child soldiers. This chamber can only rule on the allegations against Mr. Ongwen and the evidence. I understand that. But parallel to that, especially today in an age of media and computers, et cetera, there is an impact of this case, and there is a message of what it sends. And that's what I think we have to talk about. Now, we've argued from the beginning that violations of fair trial under Article 67 and international instruments have permeated this trial. The prosecution said it's probably true, we devoted 20% of our closing brief to this issue, and probably could have devoted if we had more, if the situation were different. But much of the record has been made and litigated. I don't want to relitigate here. But I do want to just identify some of the areas. I'm sure the court is aware of them, but so that others can have some sense of where the issues have arisen. One has been in notice, defects in notice. There's been a series of pleadings on this, including also on sexual gender-based crimes and the notice. Another area has been on translation. Another area has been on burdens of proof. Another area has been on the evidentiary regime. And another area has been on illegal pleas. And another area has been on the accommodations of the court proceedings for a mentally disabled client, as well as the fair trial rights which are associated to that, but are also separate. One of the points which we want to emphasize is that the violations of the right to counsel and right to remain silent started at the time of Mr. Ongwen's surrender, and I will talk about this in a moment. I've also mentioned this smorgasbord of charges and modes of liability. We made efforts through a no case to answer, which was rejected, to try to get the trial chamber to pare down this list. Right. It's probably not legal to say, it's not legal language to say it's just too many for one person, but that's really what I'm trying to say. I mean, you have to, in order to defend yourself, there has to be some clarity about what the essential allegations are and essential modes of liability. But here, it's overwhelming in terms of exercising your right to fair trial and to defend yourself against 70 times 7, 490 charges if you want to do the arithmetic. That's what we're faced with. And I will also talk a little bit about the issues of the mental disabilities in a moment. But what I want to say is that all of these fair trial violations, they're violations of human rights. And in the Rome Statute under 21.3, as we all know, the statute must be applied and the law must be interpreted to be consistent with internationally recognized human rights. Now, the defense has consistently taken a position that the violations of human rights are egregious, whether you look at them one by one individually or whether you look at them in the aggregate collectively. However you want to mix and match, there are violations of fair trial rights. Now, when we suggested that the court declare or order an immediate permanent stay of the proceedings, this was not suggested without thought or seriousness. This was not suggested lightly. It was suggested based on our analysis, looking at the last few years, looking at the violations which started from the surrender through now, that it was impossible, in the words of, I think it was Judge Fulford, that the prosecution quoted from the Lubanga Appeals Chamber decision, it was impossible to piece together the elements, the constituent elements of a fair trial. It's just too much. It isn't possible. And this is the reason why we still maintain the position, because stays, which are exceptional remedies, legally can be granted for fair trial violations. And it's our position consistently, as we've argued and as we've pleaded and as Your Honors have no doubt read in our brief, that we have an exceptional situation here. Now, I want to discuss two of these violations right now, but I want to emphasize that contrary to the representations of the prosecution, we're not basing the remedy of stay for fair trial violations only on one or two violations. We're basing it on the whole string of fair trial violations. And this is just important to emphasize in case it doesn't come out as clearly as we want it to in our brief. Okay. I would ask that the court officers place, there's a public annex to our brief on violation of Mr. Ongwen's right to counsel and his right to remain silent. I would ask that you place it on the monitor. I'm not going to go through it in great detail. And I also want to say, I did not make this. It was made by Tibor Banovich. I wish I could have, but if you could place it either on the evidence channel or the monitor. Okay. My monitor doesn't work, so I don't know if anybody has it. Is it up? Okay, you have it, all right. All right, so I'm looking at the paper. But basically, our position is that when Mr. Ongwen surrendered, the surrendered, now I can't read it because I can't see it. Okay, it's all right. But when he surrendered in January 2015 to a rebel group called Abahoro, he spent a number of days with the U.S. Special Forces, and then he was transferred to the UPDF headquarters at Obo. The proceedings at Obo in the Central African Republic were conducted at the, quote, behest of the ICC, which is the legal language, the legal standard that triggers the rights under Article 55, and as we argued in our brief, there are rights under Article 59 too as well. So that what happened at Obo took place at the behest of the ICC. Now what happened was, and the events at Obo were clearly related to, that's the second criterion, were clearly related to the ICC. So at Obo, what happened? Mr. Ongwen gets there, he appears, he has no counsel, yet he is told that he is an ICC indictee being held on the charges of war crimes. And subsequently, this information elicited from him about his surrender. Now, at this point, as I said, there's no legal counsel. He's not informed of his right to counsel, nor is he asked to waive this right. Now, this was the 14th of January, 2015. So essentially what happened at Obo was Mr. Ongwen was clearly a suspect who was about to become a defendant. He was told there was a warrant for arrest there. Now, about 30 minutes after this questioning of Mr. Ongwen, he was asked for the first time if he wanted the assistance of a lawyer, and then he was introduced to ICC duty counsel. Now, our position is that the right to counsel should have been implemented the moment he set foot into the UPDF headquarters. I would also add that both Uganda and the Central African Republic, who are acting on behest of the ICC, are signatories to the International Covenant on Civil and Political Rights, which guarantees the right to counsel. And while it does not, the ICCPR does not explicitly say this in their text, the jurisprudence is that the monitoring mechanisms for the ICCPR have clarified that right to counsel applies to suspects. And in addition, I would point out that the same provisions hold for the African Charter. So this is the very first example that we have of the fair trial violation, the failure of the ICC to provide counsel and to notify Mr. Ongwen of his right. The second point, which I will try to finish before lunch, related to this is the right to remain silent. Now, the bottom line here is that the prosecution, it was ending in 1449, submitted a video of the transfer at Obo and what happened without counsel where Mr. Ongwen was questioned. Now, the problem is that one of its experts, Dr. Metzi, relied on this video, as well as other material, to reach her conclusions that Mr. Ongwen was not suffering from any mental disease or illness. And this is testimony found at T162, page 17. Now, our position is that the video that was shown to Dr. Metzi was obtained in violation of Mr. Ongwen's fair trial right to counsel and right to remain silent. And therefore, it's our position that it was not legally obtained. It was illegally obtained. And pursuant to Article 69(7) of the statute, evidence should be excluded which would be, quote, antithetical to and seriously damage the integrity of the proceedings. And it's on this basis that we've argued that Dr. Metzi's subsequent evidence should be excluded because the video was not legally obtained, and she admitted that it was part of the basis on which she reached conclusions. Again, here we have violations of our statute, the Rome Statute, but violations also of international law consistent with the Rome Statute. Now, the second issue I want to talk about I'm moving faster than I thought, has to do with the illegal plea. Now, I've talked about this a lot in our opening statement. It's available to everyone, but I just want to emphasize two short points about it. First of all, we start from the position that a plea must be voluntary, knowing, and unequivocal. And this applies to guilty pleas, but also to pleas of not guilty. And at the December 6th, 2016 hearing, it's our position that Mr. Ongwen did not in a knowing or informed way, and did not unequivocally enter a plea. We rely on two things. One, the transcript, where he says very clearly, as a number of people have discussed here, said he did not understand the charges as being brought against him. They were being brought against the LRA. I'm not the LRA. And I would point out that approximately a month or so later, in document 1147, even the trial chamber acknowledged that Mr. Ongwen did not, quote, give an unqualified affirmation that he understood the charges. This is in paragraph 9. Secondly, at the time the plea was entered, Mr. Ongwen had read many months before the document containing the charges, but the full copy of the confirmation decision, which is the document on which the proceeding is based, had not been translated. And we've also submitted records and evidence that shows that he did not receive a full translation until 7 days, or either 6 or 7 days after the plea was taken. So it doesn't make it possible for him to have, even if it had been translated, to have understood everything there. He didn't have the material. And lastly, I would reiterate that the charges were read out in court in that proceeding, but not the modes of liability. Why do I make a big deal about modes of liability? Because the modes of liability are the allegations of how you allegedly participated in the crime, right? It's part of the charging document. So that this information is critical to an accused, to his understanding. So these are very important points and why we would conclude entering the plea was illegal. However, there's a second point which applies to Mr. Ongwen, which is that given the notice by the defense of his mental health issues, his inability to understand, in our view, was compounded by this, and they were not considered. So that for these reasons, we argue that the plea was not legally entered. At this point, I have 2 minutes, but if it's okay, Your Honor, I would ask that I could stop now and go on to the next subject after.
It's okay. We have lunch break until 2:30.
Okay, thank you.
All rise. We will look